All right, it is 1:15 by my count, so we'll get started. Welcome to the 2026 legal session, what you need to know about enforcement, transactional, and regulatory trends affecting your practice. I'll have my co-panelists introduce themselves from far end of the table over there.
My name's Paul Rudolph. I think many of you may have seen me here before. I've been coming here for several years, and I'm happy to participate in this year's legal session. My focus is going to be on payor audits, how to respond to them, how to deal with them, and with Jason, we're going to talk a little bit about the WISER program, which may have affected some of you.
Hey folks, Jason Grace. I'm a corporate healthcare attorney with Benish Law. I'm going to talk a little bit about the transactional update, what's going on in the market for OBLs and ASCs, and then also talk a little bit about AI in healthcare and how it's impacting our clients.
And I'm Murad Hussain. I'm a enforcement defense attorney and a litigator, usually focused on defending practices and providers from incoming scrutiny, whether it's from payers, from the government, from private whistleblowers and the like, but also with a regulatory bent. And I'll focus, as we start, on some of the enforcement trends, which I think will sort of help guide a lot of the other discussion, because it'll really tee up at sort of the last stage of what can happen when a practice encounters the government, what can happen when things go very wrong. And so the rest of our topics will really focus on structural questions, regulatory questions, how to sort of run your business in the normal course, in the hopes that you don't end up sort of where we'll sort of start.
We have a lot of time here today.
Yes.
And so if you've got questions along the way, please raise your hand. We want this to be as interactive as possible.
Yes. They make us do this marketing disclosure, but most importantly, we are not your lawyers yet, so take everything we say with a grain of salt. It's educational, not legal advice. Agenda, we'll talk about enforcement, quick transactions update, quick look at AI generally in healthcare practices, and then we'll spend, I think, a fair amount of time, and certainly as questions guide us, on audits and payor disputes. Paul's going to lead that piece. I certainly have some recent experience as well that I'd love to share. And then payors' use of AI. Obviously, there's a lot going on in the AI space. A lot of it is very much evolving, but it's also important to see how things are starting out so you can get a sense of whether there's a lot to be focused on in the days to come. So quickly on enforcement updates, and I've done these talks in the past. Some of these slides will be familiar if you've been here before, but just a quick primer. If you are in healthcare, healthcare is one of the largest sectors of federal government spending, and with that comes a lot of scrutiny for how those dollars are being spent. And so there are always healthcare fraud and abuse investigations taking place across the country, both at the federal and at the state level. The primary investigators that many are familiar with are the U.S. Department of Justice, which operates out of a headquarters in D.C., as well as in U.S. attorneys' offices all around the country. The Drug Enforcement Administration, they have a role, particularly with respect to controlled substances, opioids, and the like. Health and Human Services Office of Inspector General and other units within Health and Human Services, such as Medicare, CMS, and their contractors, the MACs, the ZPICs, the UPICs. They are also very vigilant. We'll talk about how, in particular. Other agencies, they have their own programs, the Veterans Administration, DOD, TRICARE, and the like. And state attorneys general are also very active, particularly on the Medicare front. Private parties are also very much in this mix, and we'll talk a little bit about how that might be changing. Qui tam or qui tam, it's a Latin phrase that refers to people who can sue as whistleblowers using the government's name in an attempt to recover federal dollars. Those could be anybody in your practice, outside your practice, competitors across the street. Insurance companies, private payers are getting very active as well with their special investigative units, often staffed by former government officials and investigators. And they're much more ramping up their activity in scrutinizing claims and in making referrals to the Department of Justice. I've had a number of cases, civil and criminal, that have erupted from an SIU seeing something going on that they thought was problematic, and then they made a referral. Maybe they went off half-cocked and made everyone's lives more difficult than was necessary, but that's another increasing source. And the press, as we saw a few years back when ProPublica launched a hit piece on a number of folks within this society and elsewhere in this specialty, just based on their data via the publicly available Medicare numbers, which are out there for all to see. And the outreach can come whether it's through a formal knock at the door or formal process in the mail, but also just what you hear, oh, my former biller got a call from somebody, they don't know who, but they could then call the current biller to find out what's going on. And so outreach can come in any number of ways. But what are they investigating? Very simply, inaccuracies and inducements, whether your claims are submitted accurately and whether anything has tainted the claim through financial self-interest. Various people have talked about, over the course of the day, the False Claims Act and criminal health care fraud laws are primarily focused on the fraud piece of this. The financial self-interest is covered by the criminal anti-kickback statute and the strict liability Stark law, which is a Medicare statute. But those really look at the self-interest that may color a provider's judgment. Common allegations include lack of medical necessity, upcoding, overutilization. In particular, these days, you're seeing a lot of lawsuits and fraud theories being enforced where profit motive because of private equity transactions are the current bete noire of a lot of these lawsuits. Also, when pharma device companies come and are marketing products that are priced at a certain point that Medicare will reimburse, but the sale price to the provider might be substantially lower. The spread between those two is something that those companies should not be marketing as, quote, marketing the spread as an inducement to purchase them. People should be buying them because they feel they need them, because they feel their patients need them. Insufficient documentation, inadequate supervision of mid-levels who then bill out at the 100% physician rate. Kickbacks, and kickbacks aren't necessarily going to be in the form of bags of cash. They could be, as the statute talks about it, things that might have value which might potentially induce somebody to use federal health care services. So that could be equity interests in an ASC. That could be a lease that you offer to somebody at less than fair market value. All of these things are things that I have seen charged as improper remuneration under the kickback statute. And then there's something which will dovetail into what Paul will talk about later on, what's called reverse false claims. Essentially, when you know you owe the government money, but you don't pay it back. And that obligation to pay back could be triggered in the course of potential audits that may find things that are systematic rather than one-off problems in a practice. Why are they investigating? Because particularly these days, the False Claims Act, which is an old Civil War era law, allows private parties to sue in the government's name. They file a complaint under seal. The government, in theory, investigates for anywhere from 2 months to 2 to 5 years sometimes. Every year, DOJ trumpets the billions of dollars it pulls in from resolutions under this law, whether that's verdicts at trial, whether that's settlements. This last year, they had one of their banner years, first biggest in a while, $5.7 billion in healthcare-related recoveries, and the relators, the whistleblowers, can get up to 30% of that cut. And over 80%, this is usually par for the course, of those resolutions were healthcare cases. But increasingly, we're seeing the Department of Justice open up its own enforcement actions. Part of that is because there's a controversy in the law about whether this whistleblower provision is actually constitutional, for reasons I won't bore you. I personally think it'll withstand scrutiny, but either way, the Department of Justice is increasingly taking the burden onto itself to launch these cases. They're placing extreme emphasis on data analytics and AI, and reviewing the data internally. Often they would rely on whistleblowers with their insider knowledge of a practice or a hospital, et cetera, as well as referrals from the auditors and the contractors who are also doing their own, increasingly AI-driven reviews, and then traditional informants, hotline complaints, and the like. But what we're seeing is out of DC, as I'm sure many of you have been following, lots of upheaval in the federal workforce, lots of resignations, lots of terminations, lots of budget cuts. What that means is we're in the middle of a perfect storm that is driving things towards AI, which we'll talk a lot about on the back end of the presentation. You have far fewer people with far less institutional knowledge on how to work these cases up who are available to actually work the cases up. And you have AI tech that is now very easy to use, potentially dangerously so, because it might be used in ways that are not necessarily going to be robust and accurate to the situation that it's being applied to. So you have fewer bodies able to do the work and great tools that on the surface seem like it's much easier to do the work with those fewer bodies. And so there's a greater reliance, as we will see, on these tools, and it's really informing a lot of what's going on. But we're all familiar with what can happen if you have an investigation and it goes very badly and you're, God forbid, tried criminally and you lose. Obviously, there's significant penalties to life, liberty, and property from losing a case, criminal, civil, or otherwise. But even if the investigation is simply ongoing, this can have very concrete burdens. You know, obviously the legal costs, the morale, the time away from the practice that your employees are spending gathering documents and seeing what happened, and the reputation. I've had clients who have had successful, quote unquote, resolutions of an investigation where it goes away entirely, but for the time that that cloud was on the practice, people didn't want to stay at the practice who were employees. Patients were wondering, well, I heard about this thing in the press, what's that about? I'm going to go find another doctor. So even when things result in a clean bill of health, ultimately they will still have their mark left on the practice. Ongoing disclosures you have to make, whether it's hospital privileges, credentialing, otherwise. They ask, are you currently under investigation or in a lawsuit other than malpractice? Medicare suspension, again, we'll talk about this, but Medicare has essentially a hair trigger suspension authority if there's reliable information about overpayments or credible allegations of fraud, and they are very difficult to challenge. I've tried to help practices challenge these in court very quickly. It's very difficult to do that, and so it's all the more important that you understand that audits can become lawsuits, can become prosecutions, and vice versa, and so once you're in the system, all sorts of consequences can multiply. And even after, as I was mentioning, things go away, even if it's a no admission settlement, say with a relatively low amount of money paid, maybe just for some claims that were paid incorrectly, and okay, fine, mea culpa. And there's no corporate integrity agreement, which is an ongoing supervision requirement where Medicare and Health and Human Services has, you sign an agreement that requires claim reviews and quarterly submissions. The government's going to issue a press release almost always. I've very rarely been able to get them not to do that. Commercial payers will start to follow on. Oh, I saw that government press release. That means you're liable for fraud, right? I actually just sent a letter to a commercial insurer saying, no, we didn't admit any liability. It says that at the bottom of the press release. You should know that because you just had your own big settlement for 10 times more than ours announced yesterday. So please don't pull through on this suspension of the client. And banks will often also cancel, close accounts, commercial accounts, just because of a government press release where it says no admission of liability. These are just allegations. So last year, the DOJ, HHS, False Claims Act working group was restarted. It was always around, but I think in the wake of personnel loss in the government, this is now sort of the new fusion center where agencies that have responsibility for enforcing healthcare fraud and abuse vigilance are making very formal their coordinations. You've got HHS leaders, and OIG, you've got DOJ's False Claims Act supervisors and U.S. Attorney's offices, and CMS's Center for Program Integrity. They're the data mongers who have access to and expertise in looking at all of these things. And this now just formalizes HHS's referrals to DOJ for potential False Claims Act investigation, particularly for electronic health record system manipulation. This is something they've been very focused on. We'll see in a moment how that's starting to come up in cases that DOJ is bringing. But in particular, because we are seeing fewer hands on deck in Washington with expertise and increased use of AI, this is now the place where suspensions are basically, Paul, what was it, sort of a Monday morning meeting, and let's just go around, where's the aberrant billing? Suspend them.
So I can just add a little color. So Medicare held a 2-day conference on Monday and Tuesday of this week, and the 1 p.m. presentation on Tuesday was from someone who's involved in this working group, which they call the War Room. And what happens is you've got 6 or 7 people sitting around a table with different areas of expertise, and they're presented what their artificial intelligence, their large data sets, their large language models have given them in terms of aberrant billing patterns. And they'll sit around a table, and one person will make a recommendation that there seems to be something going on here. Does anybody disagree with suspending payments to that practice? And if they all agree, then the payments get suspended. And apparently, it's interesting, the anecdote that she told is that Oz, Dr. Oz, who's running Medicare, this is a really high priority for him, unlike other administrations. And basically she said, this is something new. Oz proposed this, And everybody said, as Murad pointed out, oh, we've tried that before, it's never worked, it's never going to work. So apparently, sometime last summer, they had a 6-week sort of probation period where they all said, okay, let's see what we can do in 6 or 8 weeks. And if it works, then we'll continue it. And so I can't remember the exact number, but apparently in 6 weeks they identified like $15 or $55 million worth of fraud in the first few weeks it started. And so the ROI on that was so high that they've now continued it and dramatically expanded it. And Dr. Oz is now making special field trips to places that have been identified as having aberrant billing patterns. Now, they started with hospice and DME, but I think, as everyone in this room knows, and as we've been talking about for years, the bullseyes on your heads are really no different than the bullseyes on the hospices and the DME suppliers. So this is going to be a major thing for the rest of the Trump administration.
So as I, as a transactional attorney, sit here listening to this, because I didn't know this is all news to me. If you have an ASC or an OBL and you're in a joint venture arrangement with, other providers, one thing to think about is in your organizational documents, making sure that you have the right to redeem out the equity of anyone who gets hit with one of these investigations, because it can impact not just the individual, it can impact the ability of the ASC, of the OBL, to get paid. So just something to think about. We started seeing this, the first time I saw anything like this was a few years ago with a dialysis facility, and it's really a case of you're guilty until proven innocent, when they can shut off the payments and then make you have to come with all the proof that you're not.
And the funny thing about the payment suspension is they don't have to give you notice, and they do it retroactively. So I just started representing a client, a clinical lab in this case, that got a notice on March 2nd that their Medicare payments had been suspended effective January 26th. And they had only really just begun to notice something weird, but they didn't think it was a big deal until they got that letter. So things like that do happen.
The world of big data has been with us in the Medicare space for obviously a long time under the hood. They've always had the data. About 12, 13 years ago, there was like a TRO in place for decades that kept the physician-provider Medicare data from being released. And finally, that TRO sort of was vacated. And so now Medicare publishes every year an update of about 2 years lag of provider data at the provider level for every line item service imaginable. And what that means is that data is available on the internet for all to see. You can download your own data. You can download your competitors' data. Patients can download your data. Lawyers can download your data. And so it's that sort of world we're in where outliers may be overstating it, but people who are at one end of what the curve looks like suddenly have a target on their back, because everyone can look to see how much are you doing, how much are you making from Medicare alone. And that was very much what drove the ProPublica stories from a few years back. Very quickly, just some, in the last year, some recent False Claims Act civil and some criminal resolutions. These were, with I think one exception, these were largely allegations only for no fault admission, no fault settlements. Arizona Cardiology Group just last week announced, it was a 4.8, or DOJ announced it, a civil false claims settlement, about $5 million, involving perforator vein ablations and creating inaccurate medical records, in the system to support, again, this EHR issue that DOJ is focused on. This was notable because there was no whistleblower underneath the case. It was an original DOJ action. There's a sentencing of a cardiologist for PVIs. Another key time settlement out of South Florida, $810,000 for PTAs. That was a whistleblower case. But then again, we saw a big False Claims Act settlement, $45 million for a national wound care provider to SNFs and other centers. And what made that one so unusual was, number one, it was another original DOJ action, no whistleblower. But it was really focusing on the theory of pre-programmed EHR that was going to maximize by default various services. And so as part of the resolution, the provider agreed, quote unquote. If you don't agree, you're put on a naughty list of people who are heightened risk in OIG's view for not agreeing to a corporate integrity agreement. So this practice agreed to a corporate integrity agreement. Usually it's a 5-year term where you subject your claims to an independent review officer who will make quarterly reports to CMS about how you're doing. But this CIA, corporate integrity agreement, had a very novel requirement that the healthcare information technology infrastructure of the practice was also part of the review, not just claims. And so I think that EHR, EMR, that's going to be increasingly a source of a lot of whistleblower and DOJ scrutiny. And then similarly, another EHR settlement earlier on last year. 2 pending FCA cases in the outpatient space that many are familiar with. One is peripheral vascular in Texas. Again, this was a case, and just for everyone's perspective, I mean, I am a committed defense attorney. I defend practices. I basically don't take a position on any of these allegations one way or the other. But generally speaking, here in a False Claims Act case, DOJ can either take over the case from the whistleblower or decide we're not going to get involved, but we're not going to kick it out of court yet either. We'll let it ride, and you, the whistleblower, with your plaintiff's lawyer, you can try to take over the case, and we'll see if you win. And if you win, it's win-win for us. We still get it at minimum 70% of the haul, so we'll let you take this on. That's what happened in this case. It was against a vascular surgery practice. There was allegations of improper global billing and belated documentation of non-invasive ultrasounds. There was a jury trial where the relators and the plaintiff's lawyers tried the case. $4.4 million in triple damages, which is what the False Claims Act allows, triple the damage of whatever the government suffered. So the actual claims at issue were maybe 1.3 or whatever million, but it's tripled. And then penalties per claim, which can be anywhere up from like $15,000 to $30,000 per claim these days. So that's the additional $22 million in penalties. On appeal, the appeals court reversed most of the verdict, saying, well, some of the theory for why these claims were false or really mattered to the government were based on Medicare guidance, the CPT-4 manual, and what it was saying about when certain documentation was required. That was ambiguous. So we're going to reverse and new trial based on our guidance. We're also going to reverse some of the penalties and damages. And if you look at the docket today, it says the parties are approaching settlement. What this really drives home is, one, I mean, the cost even of, quote unquote winning. I mean, the doctors were successful on appeal for the most part. Maybe they will be close to settlement, but this is after, we look at this now, maybe 5 years more of legal fees, of reputational cloud, and the like. In addition, the Trump administration is currently down on using sub-regulatory guidance, manuals and the like, things that don't go through the normal agency approval process. And this case sort of reinforces why that's not the worst idea in the world to sort of have a skeptical view, because these manuals don't get the same sort of vigorous review as regulations do. But also making sure that the lawyer, I'm not saying the lawyers here did not do that, but it really just reinforces how investigators are often not healthcare specialists. Too often, frankly, they're not healthcare specialists, and so they will not necessarily have a sophisticated understanding about all the ways in which the manuals and the like are going to be ambiguous. And so this is exactly a situation where hopefully there's the opportunity to have that conversation. Modern Vascular, another case out of Arizona. Many of us are familiar with it for various reasons. Again, I take no position on the substantive allegations. This is one where DOJ did take over the whistleblower's case against a nationwide chain of outpatient vascular clinics. There, the theory was that the equity interests that were being paid to the physician investors were kickbacks because there was a link between their investment and their referral volume, and so it was viewed as a potential inducement to drive referrals and utilization of Medicare dollars. This case is interesting because it's basically on pause right now because two of the defendants, I think it was the owner and I think the CEO, a corporate officer, a founder and corporate officer, let the court know that they were under criminal investigation. This is all public and on the public docket. So they were in discovery, they were in depositions, and so they said, well, we're under criminal investigation. We want to assert our Fifth Amendment rights in this civil case because we have a well-founded fear of prosecution. And so we'd like a stay of discovery. And the court said yes. And so right now, the parties are just submitting regular updates about everything is still on pause. This reinforces that the anti-kickback statute, which is often a predicate for a civil fraud claim, it is a criminal law. It launches criminal investigations, and that you could find yourself in parallel civil and criminal jeopardy. And so the Fifth Amendment and your right against self-incrimination does matter. When you think you might have criminal exposure, you can assert it in the civil context. I talked last year about the OIG work plan report on the outpatient
Before we
vascular
move on.
procedures that are being scrutinized very heavily. Yeah.
Yeah, can I just say? I'll just say a couple things about modern vascular. The facts matter here, especially in any anti-kickback case. The facts matter, and the allegations of some of the conduct in question, things like. Well, let me start with the structure. So the structure of the modern vascular OBLs, because they were mainly OBLs, was one interventionalist and then a whole bunch of non-interventional physicians as investors in the center. The non-interventionalists were mainly podiatrists. And the allegations state that the way physicians and podiatrists were given or granted equity, number one, oftentimes equity was granted below fair market value. Number two, the equity was conditioned. Can you not hear me? The equity was conditioned upon the referrals being made, that they would only get equity if a certain number of referrals were being made. And then if someone stopped making referrals to the venture, they were out. Either the distribution checks would stop or they would be kicked out of the venture. That is, if in fact accurate, the exact thing you don't want to do with OBLs or ambulatory surgery center investments. So just want to mention some of the alleged facts involved.
What were basically the referring physicians? Each one had a day that they were the designated medical director. Is that right? I mean, on its face, like that doesn't strike me as being necessarily bad. But with it comes the question of, are they going to be responsible implicitly for driving utilization because that's their day?
Or if that medical director comes with a medical director fee, right? In which case, medical directorships are fine as long as you're actually doing the work for them, right? And that the fee is consistent with fair market value. So I anticipate that one of or more of those things may not have been happening.
Right. And to Jason's point, I mean, the fact that you have a criminal investigation, I mean, I've defended folks who have been railroaded, tried, and the government lost on all 60 counts of healthcare fraud. So just the mere fact of a criminal investigation doesn't mean anything, but it does require a higher standard to get involved. So at the very least, the facts probably didn't look good. The work plan, OIG sent out a bunch of letters just around Inauguration Day last year, maybe to sort of justify their jobs and the fear of the hatchet coming down. As we saw, it did come eventually, but they're doing a work plan on office-based lower extremity PVD procedures. They were very quick with follow-ups once providers submitted their 1 or 2 dates of service. It's been relatively quiet. I haven't heard too much about this, but the projected completion is sometime during this fiscal year, so through September. Given what we've seen in the working group announcement between DOJ and HHS for False Claims Act working group, they will be leveraging the HHS OIG reports. That's explicit part of their remit. I foresee that we may see some specific action coming out of either the report coming from this work plan or others like it, like the skin substitutes report that was a work plan that was sort of launched around the same time. And now with the new PVD codes, and obviously there's been a lot of talk about that at this conference and will be certainly tomorrow. For some context, under the old codes, 10, 20 years ago, there were too many criminal prosecutions, not just civil false claims enforcement, but criminal prosecutions based on how much stenosis is really here that we can see on the angiogram. And I've been in meetings where HHS would have this angiogram up on the screen like it's a CSI video or something, and we're fighting about, is this 60%, is it 40%? But in criminal cases, what DOJ sort of came to without a lot of robust academic literature behind it, and there were some very good joint legal and medical articles on the subject, that DOJ was using sort of a 70-30 rule, that if the doctor said it was more than 70%, but our experts say it was less than 30, that's probable cause to try to pursue a criminal prosecution here. What we now see, obviously there are a lot of different dimensions along which the new codes create different gradations, but one thing it has simplified is the complexity question with respect to obstruction. It's either basically CTO or it's something less than 100%. And that might suggest, okay, we're taking some of that off the table in terms of the parade of horribles when investigators start trying to criminalize medical disagreement about obstruction. Okay, it's either all or nothing, or all or something. If it's trickle of flow, it's not 100%, it's not complex, it's just straightforward. But again, given what we're seeing on the work plan, the working group, and what we're hearing about the driving role that AI is playing, are we now just going to see a raft of audits being launched against people who are, quote, outliers for, 100% all the time, complex all the time? Okay, you seem to be like you might be someone we want to watch. So that's something we might see around the horizon, maybe not, but it does reinforce the need for the documentation for the total occlusion, because that's going to be the surefire way to ensure that whatever scrutiny you get is something you can hopefully put to bed early on and does not become this multi-year saga. Very quickly, and I'll turn over to Jason, we have been seeing anecdotally some scrutiny of OBLs with respect to this very challenging hoop to jump through of the in-office ancillary services exception for Stark, and I'll just turn over to Jason to talk
Sure,
about
let me
that.
explain this, and I touched on it a little bit this morning. So how many folks here are part of a physician group practice? Okay, so that has a very specific meaning under the Medicare rules. Generally, it's 2 or more physicians doing substantially all of their services through a common tax ID number. There's a bunch of other rules, but substantially all means 75% or more. If you are a group practice under that definition, then a group practice can try to satisfy the Stark Law in-office ancillary services exception, which has a slew of requirements. And if you're interested in seeing those requirements, come to me. I'll give you a 1-page document showing you what they are so you can do a kind of a quick self-assessment on your practice. The IOAS exception is helpful for those practices or those OBLs, and I'll start with saying practices that are doing designated health services, diagnostic imaging services, and then lab services. That's where those are generally considered Stark Law services for the group in this room. Physician practices can use the exception. If you're a freestanding clinic, just a group of physicians getting together to form an OBL, you can't use this exception. You're not going to qualify as a group practice. So typically, OBLs, where you get together a whole bunch of community members, cannot perform these diagnostic services. So they have to be performed in the hospital, at an IDTF, at another physician office. What we've seen now, and we'll have more on this, I imagine 6 months from now, is I've gotten 3 requests for targeted audits for clients asking, number one, explain to us how you qualify as a group practice. And number 2, explain to us how you use the IOAS exception, how you meet the IOAS exception. I've never seen that before. I don't know if these guys have, but so again, we're starting to get targeted audits. We don't know where it's coming from. Again, we assume it's coming from their greater use of AI.
So just wrapping this piece up, you're all still the low-hanging fruit because looking at data, outpatient vascular is still a well-reimbursed body of codes. In fact, there are new codes now, means they're going to be paying attention to how those new codes are being used. Stay vigilant. Good faith is typically a strong defense to an accusation of fraud as opposed to just being paid too much. And in particular, and we'll touch on this later on, self-auditing yourself and making sure that you have good systems in place will keep future audits from being able to target you and say, well, you need to go back and look at everything because you don't have a clean house. And ultimately know your rights and make sure that you're responding to the government or to the payer or to the contractor very carefully and deliberately, because those things can't snowball. So very quickly on transaction updates, if you come up here and just...
All right, well, it's not all doom and gloom, so we're going to take a doom and gloom break, and we'll talk a little bit about happier things, transactions, And this is really just a quick reprieve from the doom and gloom in terms of what are we seeing out there in private equity there's been a lot more private equity in this space, a lot more investment by large corporate organizations. I'm sure you are all seeing the same things that we are, that medicine is changing rapidly. You know, it used to be that there was one level of medicine. Now you have medicine. You have doctors who are not taking Medicare anymore, doctors who are going corporate, concierge medicine. So the models are changing rapidly. And why not? It's 22% of GDP, an aging population, and you know the PE firms still, for the most part, see that there's money to be made. So I'm just going to quickly give a quick anecdotal summary of deals that we've seen in the endovascular space. And when I'm talking about endovascular, I'm talking about cardiology, vascular surgery, interventional radiology, and then to a lesser extent, nephrology, call it maybe the vascular access platforms as well, because there have been some bigger deals there. And there's really two types of deals that get done. If you are a large organization that's got multiple sites under management, that's typically referred to as a platform deal, where you know you are going to go and sell your entire platform. It's going to be the basis upon which private equity would launch a national platform. Those are bigger deals, and because of that, you get a premium. You know, I think most of the people in this room probably have one OBL, two OBLs, so those aren't platform deals. But what we saw over the last, I'm going to say 12 to 18 months, I wouldn't say this is, you know, 1 year, is that the platforms are selling for between 9.2 and 12 times EBITDA multiples. So think about net profitability as a proxy for EBITDA. And so I put up here some of the things that are driving deal premiums. So sourced by sell-side advisors. I guess this is my pitch for, go get yourself a broker. If you want to sell your business, it's like selling your house. You can put it on the market yourself, but you're not going to get as high of a rate. It's the same thing with a business, and business brokers do end up, from what I've seen, paying for themselves. Operations concentrated in CON states, especially where we're talking about ambulatory surgery centers, because CON, remember, it's a protectionist measure, right? Your hospital system down the road or your competitive ASC is going to come and try and keep you out in CON states. If you're not CON, if you don't have an ASC and you've got an OBL, it's essentially ready to be converted. Multiple specialties are always going to be more valuable than single specialty centers in the context of these platform deals. This was something that we've seen, direct-to-consumer driven marketing instead of physician joint ventures. So if you're going out there, and we've got some great marketing presentations this afternoon. If you are going to the community and you have a strong, direct-to-consumer presence, it actually, obviously can help to help in the event of a sale. Strong growth and expansion plans, and an established leadership team that can demonstrate success, because you ain't going anywhere in a sale. They're going to want you to stick around for 3 to 5 years. If you're doing a good job, they want you to continue to do a good job. Deal impediments, things that have made it harder to get up to these levels, regulatory issues. Oftentimes a buyer will come in, and we've diligenced a number of cardiology deals where we've found Stark Law issues. And the other thing that we've seen is California's a tough place to get a deal done. And if you have a lot of operations in California, you're likely not going to get the same multiples. I imagine folks in this room, if you're thinking about selling your practice or selling your ASC or selling your OBL, it's a different experience, right? It's a smaller enterprise. So, you typically, what I've seen is somewhere between 4 and 6.2 times EBITDA multiples. Don't believe the hype in terms of the, what we refer to colloquially as the clubhouse deal. Your practice probably isn't worth 8, 10, 12 unless you're a big deal. And it really depends who your buyer is. If you wanted to go and sell your practice to your local hospital, you're not going to get 4x. They're going to give you the depreciated value of your assets, and they'll give you a couple years of an income guarantee. So hospitals won't pay this. Your partner coming up, who is your exit plan, he or she isn't going to pay this. This is truly just for private equity. Deal premiums, again, some of the same factors come into play here. Deal impediments, again, some of the same factors come into play here. The difference is oftentimes we see some of these sales, where you've got certain physicians who have misaligned expectations of what they're going to get out of the deal. But this is just want to give a quick primer on kind of what we're seeing in the market. AI in healthcare. Yeah, sure, and you guys, of course, will weigh in here as well. So AI in healthcare, we were talking earlier in terms of the impact that we're seeing on the practice of law. Just in the last 12 to 18 months, and it's amazing all the tools that are out there, and our associates are using it more, our colleagues are using it more, sometimes to their own fault, and there's been a lot of cases out there where a lot of attorneys have misused that, but there's, it shows tremendous promise, and hopefully I'll be here next year and I'm not replaced by a bot. But we just don't know. And I think, we all feel the same way to a certain extent. So AI has its uses. I think in medicine, you guys are maybe a little bit further behind than we are in terms of the predictive language models, right? There's still a greater degree of medical discretion that, AI is not going to replace, at least yet. But AI is dangerous. It's a benefit and a burden. So you just have to be careful in terms of how you're using it. For example, we're helping a client in a situation where they were looking for practice patterns and uploaded all of their patient data into AI. Brilliant, except they just created a huge HIPAA issue for themselves. So you just got to be careful in terms of how you're using it. Top AI protections. So if you were going to contract with vendors who are heavily using AI, same sort of thing as I just described. If it's a HIPAA breach for you, it'll be a HIPAA breach for them to go and put your patient data in. So you got to make sure that you sign strong BAAs with them, not just signing a BAA, just making sure that they have cybersecurity insurance, that they have the right protection, that they're going to provide you with indemnification. Oftentimes, BAAs feel like a throwaway to a number of our clients. If you're dealing it with AI, just make sure you're giving those agreements a closer look than you have in the past. Can AI commit malpractice? A lot of doctors are throwing, symptoms into AI and asking it to spit it out. And, it's similar to what we're telling our associates. It's a great starting point, but you don't end there. You got to go to the medical journals. You've got to talk to others. You've got to seek second opinions. So don't rely upon it. AI can't commit malpractice, but it can cause you to commit malpractice, at least right now. And then posture of broad AI regulations, it's a patchwork. If you think that the EMR regulations and the telemedicine regulations are bad, we're at the beginning of what I think is going to be a very long road for figuring out AI, and there's some use of it, and Paul's mainly is going to talk about the wiser model and how this is impacting providers in a number of states, but the states are becoming very active in terms of AI regulations in a bunch of different ways, both in terms of HIPAA mini laws, consumer protection laws, and so laws will likely continue to evolve over time. So to be continued, it'll be interesting to see.
Hi there. So I can see my slides up here. So I'm going to talk a little bit about what's going on with audits and payment suspensions. So you all know there are multiple types of Medicare administrative contractors. They perform all sorts of audits. They have different authorities to do things. Whenever you get a letter, you need to read it very carefully to know which auditor is sending you the letter, and because you may deal differently if it's like Noridian doing it versus if it's one of the Z-Picks or U-Picks or one of the RACs. They usually, if you're getting audited, they start with a probe audit of 10 or 15 claims. If your error rate is more than 20%, 25%, you're likely within 6 to 12 months later to get a much bigger audit that may actually involve a statistically significant sample of claims. So they can come back and say, well, you failed this audit, you're 50% error rate, so you owe us $1 million from the audit. And then, by the way, under the Medicare overpayment rule, which we'll talk about in a minute, you then have to go back 6 years and look for all similar claims that we denied, and that's what you really owe us, not just $1 million from the audit, but maybe $10 million over the last 6 years. So one of the reasons to always appeal denied claims through an audit is to avoid a situation like that, which I'll get into. We talked a little bit earlier about suspension of payments. I'll just repeat that Medicare can send you a letter saying your payments are suspended. They usually give you a reason in the letter, and most of the time the reason is because there are credible allegations of fraud, or they don't tell you exactly where the allegations came from or what the fraud was. And the ones I've seen have always been retroactive, so you get the letter on March 2nd, but your claims stop being paid on January 26th. And again, I don't want to repeat things for people who were here before, but at this presentation that CMS made on Tuesday, they made it very clear that under this current administration with Dr. Oz, this is a very important tool. They're going to continue to use it and may use it more and more. And as Murad said, one of the things they might use it for is outliers for a number of complex versus simple lesions under the new coding program. And as you all probably know, this WISER program, which is to get rid of waste, fraud, and abuse, the program is using, and it's in 6 states, they're using a different type of AI, usually borrowed from commercial payers who have already been using AI for years to analyze claims. There's a different AI vendor in each of these 6 states, and doctors submit for prior authorization to the AI. If the prior authorization is given, then you can submit the claim, it'll get paid. Of course, it doesn't mean that they can't change their minds later and do a post-pay audit if they want to, but it should get paid. If you don't do prior authorization and you do the procedure anyway in one of these 6 states, say in this case for kyphoplasty, then your procedure will automatically be denied, and then you have to start appealing it afterwards. So you're hooked one way or another in these 6 states. And I believe the two most pertinent things is a list of 14 or 15 procedures, but kyphoplasty and use of skin substitutes I think are most pertinent to this group. And of course, commercial payers have been using their special investigation units for years to identify aberrant patterns and to send demand letters to physicians. So as I said, you get a letter, you have to read it really carefully. I cannot tell you how many clients I have where they get a letter saying we want to audit you, but the letter goes into the trash, or it supposedly goes to an office that's closed so nobody ever saw it, or it goes to the wrong person, or this or that, and then they miss the deadline, and then they get a letter saying, well, you didn't respond to our audit request, you owe us $1 million. So all offices need to be set up in a way to make sure that Medicare has your correct and newest address, which is obviously part of the regulations for revising your enrollment, so that if you get a letter, at least you know you're going to get it, and then you have to instruct whoever opens your mail to make sure that if there's anything related to Medicare on it, you at least see it so that you can figure out whether you have to do something or not. If you do get a letter saying you're being audited, usually you get 45 days to submit your records. There are different rules for different kinds of audits, but it's usually 45 days. You should almost always, and it's a laundry list of stuff they ask you for, business licenses, all this stuff that's probably not relevant. So it's almost always a good idea to call the company up and say, okay, can you explain why you're doing this audit? What do you really need? Do you really need all this stuff, or can we shorten it down? And ask for an extension. It's amazing how many practices I've represented where they say, oh, 45 days, I can easily do it. Even if it's 45 business days, then of course nobody does anything, and there's a fire drill in the last 5 days, and they could have easily avoided that by asking for an extension, because Medicare will almost always grant a 2-week extension. They rarely will grant longer than that, but 60 days is significantly longer than 45 days. If you do get audited, you'll get the results. Even if it's a small error rate, you will get a demand letter from the local contractor. So if it's a Z-pick like Clarent does an audit, they say you have a 30% error rate. We've identified that you received $100,000 in overpayments. Don't do anything now, because you'll be getting a demand letter from your contractor, say Noridian, and then you will get a demand letter, and then that's when, and that demand letter will include all the denied claims, and that's when your appeal process starts. When you get the demand letter, they'll list the claims, and then you'll have, I think you have 120 days to appeal for the redetermination. There are different I don't want to bore everybody with timelines, but they're easily knowable, how many days you have where you have to respond. And then, of course, there's times if you don't respond even faster than your actual limit, they'll start offsetting money to get the money back at the very beginning. You probably all know the first phase of the first stage is by the contractor itself. The second is by this qualified independent contractor called a reconsideration. Then you go to an administrative law judge, and then a Medicare Appeals Council and a federal district court. The reality of it is that you'll probably get denied and turned down at the first two stages, the redetermination and the reconsideration. The best chance you have of winning is usually at the ALJ level, which I'll talk a little bit about. However, even though you're likely to lose, it's usually a good idea to try to get it all right the first time, because if you do lose, it'll save you a lot of time and work when you have to resubmit to the quick later on, because the time frames are short and you don't want to have to do all the work the second time around.
To jump in, that as you go up in the process, if you don't include the issue early on, it becomes easier and easier the higher up you go for the decision maker to say, well, we're not here to be a trial court. We're not finding new facts. You didn't put it below. It's been waived. So you have to, what they call, preserve your issues early on. Otherwise, you can't raise them anymore.
Right. And what happens is at the second stage reconsideration, you have to submit all your evidence. And that means anything that you want the quick or later on the ALJ to consider has to be submitted at the quick level. This could be medical records, it could be angiograms, it could be testimony from someone who was there, who knows something, it could be anything, which is why at the reconsideration stage, it's usually advisable to hire a lawyer to make sure that you do submit all your evidence, to make sure the evidence is organized in a way which an ALJ could eventually understand and make sense to an ALJ. And I just threw in here the line, which is unfortunately true, is that the quicks, the reconsideration stage, they often take the position that they can't second guess the contractor at the first stage, which is not true, but I've seen a number of denials saying, well, we don't have the authority to overrule the contractor that denied you on redetermination, which is very silly, but it happens quite a bit. So the reason why you have the ability to win more at the ALJ level is that these are actually human beings who generally are, at least I found, to be pretty sympathetic to doctors who are trying to take good care of patients. The second reason is they're not bound by the LCDs and the stuff that's issued by the contractors, because they're reviewing everything what's called de novo. And the opposing side, namely the quick or the contractor, sometimes even the original person who did the audit at, say, the UPIC, they usually don't show up. So it's just you there, and if you have a good healthcare lawyer, the lawyer will make an opening statement. The lawyer will then directly examine the physicians to elucidate exactly why the treatment was done. You go over the medical records, all that kind of stuff, and oftentimes you can win. And then going beyond an ALJ usually costs a lot of money, is pretty fruitless. The Medicare Appeals Council, I have never seen a case where they overrule the ALJ. If anything, the most they'll do is remand it back to the ALJ to fix something or to tighten up something, but you very rarely get much going. And then go to federal court, that costs a lot of money, and I've never seen physicians do it unless the amount of money at issue is extraordinary.
I had one client who we did file a cert petition to the Supreme Court. I would not regularly advise that. The court did not grant the petition.
At the last one I did, it was really interesting. It was at the ALJ level. The contractor and the quick did not show up, but the physician who did the initial review at the ZPIC or UPIC, whatever it was, did show up to try to provide his side of the story as to why he thought the care was substandard and why the procedures were all medically unnecessary. And this was a group of cardiologists that these were all peripheral extremity revascularizations. I think most of them were atherectomies. So he actually did appear, and that was an interesting dynamic because he was only an interested party. He wasn't a direct party. He was an interested stakeholder, you might say. So I, who was the lawyer, I was not able to cross-examine him because of the rules. So he made a statement, and then I had to examine my clients to explain why his statement was wrong. And it was a very interesting dynamic. But the ALJs, and we were very lucky. We won almost every claim on that one. So if you hire an experienced healthcare lawyer who really knows what they're doing, I really do think you've got a good chance to win at the ALJ stage.
And I'll just say something on the knows what you're doing. So I'm a corporate healthcare attorney. You don't want me doing this. You don't want your labor and employment lawyer doing this. You want Paul doing this? You want Murad doing it? There's a
Even you, Jason.
No. There's a small cottage industry, just like within your folks, right? I mean, everyone's becoming super specialized. The lawyers who do this tend to have, the good ones, have a clinical background. They're nurses, technicians. Paul's a doctor. I mean, because they're speaking two languages. They're speaking, the legal framework, plus they're able to speak to clinical care, clinical needs. So just make sure if you find yourself in need of someone, ask the question, what's your background before an ALJ? Are you able to speak their language?